My name is PROCEED-Nkr, an advocate of the High Court of Kenya, and I want to say this afternoon, having seen the notice by the AGGREY MUCHELULE JA with regard to the 4 IEBC commissioners, I want to say that the notice is proper, it is in accordance with the law, and it accords with the provisions of Article 251 of the Constitution that says that once a tribunal is established for purposes of investigating, for purposes of hearing, for purposes of interrogating a petition that has come from Parliament, the role of the tribunal is to listen to the petitioner. The role of the tribunal is to listen to witnesses of the petitioner, listen to the respondents, who for purposes of this matter are the IEBC 4 commissioners, Madam Chirera, Nyangaya, Justice, Francis Wanderi, as well as Irene Masit. Though 2 of them have resigned or have issued notices that have been circulating in public. In law, what it means is that these commissioners have a right to be heard still because the petitioners are yet to withdraw their petitions. So we still have petitioners who have petitioned Parliament. Parliament has already recommended the establishment of a tribunal. The commissioners have been suspended by the President of the Republic of Kenya, who has proceeded to constitute AGGREY MUCHELULE-led tribunal. What it means, therefore, is that before the petitions are withdrawn, before the petitions are recalled by the petitioners, we still have live matters before the tribunal, and all the respondents, who are the 4 IEBC commissioners, have a right in law to appear, and that is why the tribunal has given notice to all of them to appear before them. As to whether there are going to be advantages or disadvantages for those two commissioners who have not resigned, they would have an occasion before the tribunal to explain what happened. They would have an opportunity before the tribunal to call evidence. They would have an opportunity before the tribunal to explain away some of the allegations which were made by the chairperson of the IEBC, Honorable Chebukati, who very clearly, in no uncertain terms, cast aspersions on the character, on the reputation, on the integrity of some of these commissioners. So it accords the commissioners who have not resigned an opportunity to clear their names before the tribunal and before the international community, which is going to follow these proceedings from the plenary of the tribunal. The advantages to those who have resigned is that they will not be grilled, they will not be exposed, they are not going to air their dirty linen before the public, before the international media when the tribunal proceeds. But of course, they will not have an occasion to clear their names as is expected. One thing that is very clear about Article 251 of the Constitution is that the tribunal is supposed to make recommendations, and the recommendations are binding of the president. These recommendations would be that they have established that the allegations in the petitions accord with the law, and therefore these commissioners are supposed to be removed, and if they make recommendations for removal of the commissioners or any commissioner, the president do not have a choice but to remove them. But if the tribunal proceeds to make recommendations and state that there is no sufficient evidence to support the allegations in the petitions, then they are going to recommend to the president that these commissioners should not be removed and should continue serving the Independent Electoral and Boundaries Commission, and the president do not have a choice but would have to accord and respect the recommendations of the tribunal. There is no reason why Chirera and Nyangaya should be summoned before the IEBC, because effectively they have resigned. What the tribunal was supposed to establish is whether they are going to be removed or they are going to remain. They have removed themselves. So there would be no recommendation on their removal or non-removal because they have already removed themselves. But procedurally, the law requires that so long as there is a live petition, and in this case the petitioners are yet to withdraw their petition, it means therefore that they have to be given a chance to appear before the tribunal. When you also look at the resignation letters, they are addressed to the President of the Republic of Kenya, who may not be the appointing authority. So there are legal issues, there are legal challenges that might arise about their resignation letters, together with the fact that the petitioners are yet to withdraw their complaints against Chirera and Nyangaya, and therefore, procedurally speaking, they should be given a chance to clear their names if they so want, until they confirm to the tribunal that they have actually resigned and are not interested in following up on the proceedings.